Thank you. Well, welcome all, and this is, I don't know which meeting this is of third of the Notarial Acts work group. And we did have a notes of the March 6th meeting, but I didn't quite.
I think I was running on Friday and neglected to send those out. I apologize. I will get those. I can review just really quickly. That was a reconvening of the group after we hadn't met for a while. We talked about the two models around the country, the Alta and the Rulona, which have been used to incorporate remote notarization into various statutes. We were planning on discussing that today. We talked about whether or not we'd want to see a demonstration, which we have set up today, and just kind of some foundational principles of, well, first of all, we voted on whether we definitely want to go forward with this project, and we decided to, and Lise is here today.
Okay, great. And since we have Renee out there in the ether, hi, who's going to show us what we're really talking about here.
All right. So I think we'll start with where we're going to start on my side is, as long as everyone can see the screen, is the initial invite that a signer would get from someone's software. Usually the software solutions out there can be a meeting invite. If it's a closing, sometimes it can be directly through your lender's portal. This one is just showing a typical way that you're invited to come to a signing. And this is a real estate transaction. So there is an invite process. Our solution also allows signers to bring their own documents, meaning they're just Googling and they find notarized, or they know about notarized because they've had a document.
Renee, excuse me, I don't want to interrupt you, but I don't think we're actually just seeing you. We're not actually seeing your presentation.
Oh, really?
Yeah.
You're not seeing the email. Okay.
Now we have it.
Okay.
All right, give me a second.
No, we have it now. We did. Sorry.
Oh, we did? Okay.
We did. I apologize.
Okay. Let me screen share.
Now we have it.
All right. Now you can see it?
Yep.
Awesome. All right. So this is that initial email where the consumer or the signer actually is invited to come sign a document, as opposed to they have a permission slip or some other, that they have their own power of attorney that they want it executed, that they just bring it to the platform because they're looking for something. So this is the invite process. So I get an email that says, hey, Renee, you've got some documents to review before your closing. I click and it's going to take me to the closing. The initial screen is going to require me to set up a password. And I'm going to set up a real easy password, and it tells me, oh, Renee, you have to set up a more complex password. So I think that's one of those first lines of defensive security that we like to highlight. And most solutions have the same thing, which is you need to have some kind of password to get into the portal. Again, this is a closing, so I'm going to go through the closing process. It tells me a little bit about where I'm at in the process. You're scheduled to close online. I can review and sign docs and meet with the notary online. So I'm going to get started. And the first process here is it's telling me, hey, Renee, you've got a closing today. You're scheduled to meet with your notary. And I say, okay. And then also the solution tells you there's one document you can sign ahead of time, which is that e-sign disclosure document that is in every package. And I believe most solutions should have that, which is the basic tenets of e-sign and UITA, and all kind of put together in 1 to 2 pages as a consumer saying that I want to go ahead and use electronic signatures and electronic notarization. So I click start signing. And in this process, I clicked backwards, sorry, hold on. Next. All right, so in this process, I get to scroll down and I can see that here's my form. I can scroll through the document. Right here, it's got all the information I need. I can review ahead of time. And again, this is a document that doesn't require a notary to actually apply a notarization. So I'm doing this before the notary joins. I'm just agreeing to use, again, those electronic signatures. I click to apply my signature and it says, essentially it's that consent saying, I agree that the signature and the initials above shown will be my electronic signature or initials. Again, a requirement of both e-sign and UEDA that I am going to adopt this electronic signature as my own, which is important when we get to that notarization process. So I agreed to both this representation of my full name and my initials. For ease of use today, I'm only showing this version. However, we do even allow you to draw or doodle your name down or upload a picture or image of your actual signature if you wanted, even though it has the same legal validity as this signature here that I'm going to adopt and create. So I go ahead and I apply that, and now I'm going to apply my initials that I just adopted and created, and I go to the next document, and it says, hold on, this is a document for review only. You'll sign this in your meeting with your notary. And again, even if typically if I were bringing a document to the solution on my own and it's something I just wanted a one and done document, again, I think the typical one we always use is child permission slip for leaving the United States. I would sign everything at once and meet that notary for the actual notarization. But here in the real estate solution, I'm going to go ahead and just kind of scroll through, and I've got time to read ahead of time. Typically, lenders are also providing these documents in their own portal or in some fashion ahead of time as well. So I scroll through and I say I'm complete for now. So right now, we'll have a notary that will join us momentarily, and it's allowing me to go ahead and set up the audio and video. So this is one of those key pieces that you'll find in the MBA and also model legislation, which is you want to make sure that they have adequate internet access and that it's going to be a continuous or uninterrupted real-time meeting with that notary, and it's also part of the RULONA 2018 amendment as well, that synchronous audio feed. So that was what that check did. Our system does it automatically. Other systems have the user actually do the checks themselves. So here is where we get to the first part of the identity verification. What this is doing is it's going to gather some key information about me as a signer, and it's what we call seed data. It's the data that is used to be sent to third parties for those knowledge-based authentication questions. Essentially what happens is those third parties use the seed data to first find out if there's an identity out there that matches this claimed identity. So I say I'm Renee Alberti, here's my birth date. They'll use that seed data and I'm just putting in all of this information is not my actual information. This is all a test account, so hold on 1 second. 1, 2, 3, 4. I have put in the last 4, my social security number and my address. Other solutions may pass the information over directly from the lender. Here we want the the consumer, every single time to put in their own information. That way we know it's the information of the person they're saying they are, not the information they provided earlier up front in the solution. Meaning if you took a mortgage application, the information from that mortgage application sometimes will be ported over. Here we want the signer every single time to put it in. I don't know if there's a preference, but our preference really is to have the signer provide it. So now they're going to take that data and ask me some knowledge-based authentication, or what I think we've been calling KBAs, again, knowledge-based authentication questions or out-of-wallet questions. Those are those questions that typically, if I stole your wallet, I wouldn't be able to answer the questions. They're about your public and private record information, usually based off of credit reports as well as DMV records and other somewhat public records. So here I go, and this again is the KBA. I get 2 minutes and I have 5 questions. What the MISMO standards require, and if I'm going too fast or throwing around too many acronyms, let me know. The MISMO standards require that it's only 1 retake and that at least 60% of the questions are brand new. That way, if I'm actually not me, I'm still getting extra questions. And again, because it's timed, I'm realizing I'm long-winded. Hopefully, I make it through. Got 1:30 left. Because it's timed, it also makes it harder for someone if they wanted to, let's say, try to Google every single one of these questions, chances are they're not going to be able to find this information, one, at all, or two, if they are, in the time frame of 2 minutes. So you'll notice here, in this process, it's telling me to correct answers, again, because this is dummy information, and we're not putting our own personal information up on the screens for everyone. So I scrolled through, I selected all of the correct responses, and I pressed submit. And it says, congratulations, you successfully passed. So that's the first piece of, one, I know that there's an identity out there because you passed me that seed data and I sent it to the third parties. Then the second piece being that the third parties use that seed data to serve up those questions. So now I know that you can at least answer questions about yourself. And then this third piece is going to be the credential analysis. So this is what, the only thing that a notary typically does in real life is look at your credential to say, is it you? Does it look like you? Does it look like it could be a Massachusetts license? You know, this is actually now taking this process and automating it. So I'm going to say I have a driver's license, even though I'm not using my driver's license, and I hold it up to the screen, and it's my state bar card. And I say, okay, that looks like it works. I confirm and continue, and then it's going to ask me to take the back of my driver's license as well. Hold on. Zoom in. All right, so now I take it, and I can retake the photos, and it's got some common mistakes. And then in the notary side, the notary can also ask the signer to retake a photo or even upload additional IDs if they feel like they're not comfortable. And we'll see that when we get through. I don't think we'll probably go through a second ID here, but so I hit confirm and continue, and at that point, all of the front and back images are sent to the third party that runs algorithms against that ID, whether it's a driver's license or passport. And once they have done, typically they run a number of tests. The MISMO standards require at least one automated test. Again, both Rulona, the amendment from 2018, and MBA also allow for the credential analysis. They're not detailed as to the exact requirements of the credential analysis. Usually that's left for the regulations, which is where the MISMO standards or guidelines come in or can be useful for this group in the future. So it says, let's get started with the notary. And on the other end, my colleague Ryan McGinnis from our marketing team should be joining. Unfortunately, Michael Chodas, our general counsel, is very, very sick today. So we've got Ryan joining us. All right. Hold on, let me make sure this is video. Okay. It says the expected wait time is over 10 minutes. It shouldn't be. Oh, Ryan's right there. Awesome. Hi, Ryan. Oh, I can't. Oh, so Ryan doesn't have his volume on. So what we're going to do is, on my side, I'll show you the execution process over here. I'm going to look at this document. There is certain information. Oh, where'd Brian go? Are you there? Can't hear you. Hold on. Now? Nope. So there is this helpful button that at least tells me who Ryan is. He's the notary, he's from Virginia, here's his information. So if I did want to look it up as a consumer, I could go to the Virginia website to see that he's an actual notary. Ryan, can we hear you now? Nope. All right. Still cannot hear you. Can you guys hear him, or is it just me?
We cannot.
Okay. So typically Ryan would join each of our notaries in our company have essentially a script, and they ask, are you entering out of this under your own free will, free from duress or coercion? Ryan could even ask me as the signer to move my computer screen around the room if I have the capability. So like I have a laptop and I could just zoom around the room. and he kind of goes through his initial, wait, Ryan? Yeah. So he goes through a whole, basically, I hate to say a script, though, it's very detailed. That way we have everything on camera and it's being recorded. So I think the one thing also to note is at this point, the recording started when Ryan and I both joined. Those knowledge-based authentication questions, as well as the credential analysis, is not videotaped because that is not information that we feel should be videotaped. And I believe every other provider, well, I can't speak for every other provider, but the law only requires the AV recording around the notarial act be actually captured, which includes that initial portion of whether someone is, finding out if someone is under duress or coercion. So we start at the beginning and then we end after the last document is notarized. So here on my side, I can also open settings and change my AV settings. Ryan also has the capability of letting me know that he can't hear me. So that if at any point in the meeting, if it's not working or we can't hear each other, he can cancel the meeting or I can cancel the meeting. If I can't hear him, in this case, we'll move forward. So on Ryan's side, he was served up with an image of my the credential that I was provided, or provided the solution. He can compare it to the information on the document or the information that I provided as well. And then he can ask me to retake. And after Ryan leaves, I can always just show you the notary side if we'd like to look at that. So here we are at the document. I go through and I'm going to add my initials, and it says, hey Renee, we've already got some initials on file. Do you want to use those? Again, please verify that you want to adopt those as your electronic initials. And I say yes, and I reuse them. The other nifty thing I have here, so we don't have to do every single one of these, is I can click up here and say, I have reviewed and approved this document and are ready to sign an initial everywhere. And I'm going to do that. That way I don't have to. On a per document basis, we don't allow adopt your initials at the beginning or signature at the beginning and auto sign every single one of these documents. So we scroll to the bottom, and this is kind of the important part. This is where Ryan comes into play. You'll see that I can't, on my screen, fill out it. Ryan on his screen has areas tagged where he'll fill out the information. And this is that notarial certificate. He applies the signature, and then next he should be applying his seal. Again, this is a dummy seal. And then at the end, Ryan, we're not on his screen. Ryan goes ahead and he locks the document. So then, this is that part about tamper sealing. We want to make sure that it's tamper sealed so that in the event someone tries to alter the document, it is very evident that they have. You'll see that lock that came up on my screen. And Ryan has locked all documents. And I think we're completed with closing. I only had two documents in this package. So I do have another one ready in case we want to go through anything else or go over anything more closely. And then on Ryan's side, he has a full set of audit log information. And on my side, I'm then sent an email, and I will show you guys that in a second. Hold on one second, let me pull that email up. That has a link to my document, and I get to rate Ryan. I'll say he was a rock star, good engagement, and I submitted it. And my documents will be available in a minute. And this is if I guess at the end of the closing, if I were going to pay for the notarization myself outside of a real estate closing, I would then, after the notarization is complete and I'm satisfied with it, I could submit my payment information. So hold on, I'll pull up the screen with the final documents for you guys. Give me a second. And then Ryan, thank you, unless, no, I think that's it for now.
Any questions in the room? Everyone's been lulled to sleep.
I'm sorry, I had a difficult time differentiating what you were saying about when a person.
Up my screen. So I received this email that said, your documents have been successfully notarized, and then I can log back in and view and share those documents. And then if this were a mortgage closing, which this was supposed to be a fake mortgage closing, the lender gets a copy of those documents as well. Notarize automatically sends a copy of those documents to the lender if the applicable lender is signed up for the platform and wants that to happen, or the title agent, or possibly the underwriter, again, depending on the parties involved in the transaction or what they've asked for. So here it's telling me it requires payment, and I cannot see the document at this moment. So I must have set something up incorrectly here. Please excuse me, this is my first demo, so I will have to pull those up, but I think while I'm doing that, I guess we can start with any questions.
Heather?
Or do you need me to go over anything again? I know I zipped through it.
We've got a question in the room here.
I have 4 questions, and all of them relate to non-real estate closing transactions.
Can someone get closer to the microphone, sorry?
Hold on 1 second. It's actually not Renee, do you mind actually calling into the phone? I can cut you off this and do the questions, because the way the microphones are set up, it'll be a lot better that way.
Yeah, do you have a phone?
We do
Or are you using the phone number?
Yeah, it's actually the one that I had sent. I don't know if you received the email I sent to invite the meeting. It's a Zoom email.
I did not.
You did not.
Hold on.
Let me send you that really quickly. It's from me on.
Give me 1 second.
No problem. From me on Friday. That will make it easier for questions. I can give you the number too. Oh, perfect. If you have that, what I think we'll do is I'll actually hang up this video presentation, and if you can call in, that'll just be easier to have the conversation.
All right. Hello.
Got it.
Okay, have at it.
All right, Renee, I'm going to cut off your video. Thank you.
Okay.
And now people can ask questions.
All right.
So this is Heather Gilmore, and I had 4 questions. All of them are related to non-real estate closing transactions, because the software looks great for those kinds of situations. It's totally appropriate. But I'm more concerned about non-real estate closing transactions. And so I wanted to go through these questions with that context. So when a person gets an initial email inviting them to a session, they, for example, find the contact for a notary on Google, or how do they find that and originally get the invitation email?
So for a non-real estate transaction, there is no actual invite email. What will happen is I'm just looking for remote online notarization services, and I bump into Notarize, or I'm looking, let's say I go to the Secretary of State's website and they have a list of remote online notaries who have been, either commissioned or registered as online notaries. It'll list what solution they're using, and possibly, it depends on the state, have the contact information of the notary. If it lists a solution, then at least I know where to go to have a remote online notarization performed. On our solution, currently we only have employee notaries. That may change in the future. We're discussing that, but so right now it would be you see that Notarize is either a registered platform, or that the notary is using Notarize. You go to notarize.com and you start at that point where you make up your own account. You put in your email address, put in your username and password, and then you start with that seed data and credential analysis, seed data, KVAs and credential analysis, and then you're joined by a notary. I know in other solutions where they don't have employee notaries, you may be able to actually reach out to an individual notary, but I'm not sure exactly how that would work. So typically it's just, you go to the solution and they have, either their own independent contractor panel or their own employee notaries who will serve you. And then you'll have the information about that notary. Like I had showed you that as the user, I had the information about the notary. I could double check to make sure that they're an actual notary. And on our solution, you don't pay till the actual notarization is completed. So if at any time you felt uncomfortable, you would cancel right out of the transaction.
So I Googled it and essentially I click on a link and I make an account.
Yep.
Okay. Tell me about when a person has their, for example, they would like a power of attorney notarized. So they have the physical power of attorney in their possession and they want to have that notarized. I did not understand how that occurred. Can you help me understand that?
I sure can. So in the situation, and I guess this could even be incidental to a real estate transaction, but in the situation where I, as an individual, just have a power of attorney that I would like executed, I would have to take photos or scanned in digital images of that document and upload it to the platform. So that was the missing piece here is, so I, as a consumer coming to the platform forget the real estate transaction, I create my account and it says, okay, great. What document do you want notarized? We obviously need copies of that. So either take pictures of it, they have to be quality images, or upload files, and then you start that process. So that would be how that power of attorney would get uploaded.
And the notary records both video and audio feeds?
Correct.
The questions that you showed us, were those typical questions for verification? And they were the address, the area code, what vehicles they own, what county they own?
No, that wouldn't be all inclusive. Again, it depends on how rich your credit history is, as well as your public records information. We use LexisNexis, and LexisNexis actually has their own threshold of where they don't, if they don't find enough information about you, they won't move forward. For our purposes there, those were all just sample dummy questions. So it could be, I've done these before, where they asked me what my first car note amount was, and like they can be very tricky or a little bit easier, but it's not the same group of questions for every single person. I mean, it feasibly could be, but it's not typically.
Can you give me an example for an elderly person who doesn't have a rich credit history, what the questions might be?
I really can't offhand. It's something I can definitely look into to see if I can actually reach out to LexisNexis to find out what that would be. We do rely on them to come up with that set of questions, but I will, if you want, I can follow up with you.
If you would do that, that would be helpful to me, at least, based on kind of what I'm supposed to be doing for the estate planning elder law section.
They get really creative with them too. They'll ask relative information, like who are you related to that lives in New Mexico.
Yeah, and part of that is my concern,
Yeah.
because naughty nephew will know the answer that grandma's always lived in Salem, Oregon at area code 503 in Marion County.
Yeah.
And they'll know that cousin lives in Idaho. So that's kind of why I'm interested in what those questions look like.
One of mine was, I had two Volvos that I owned within a year of each other, 1997 and 1995. One was red and one was green. And the question was, what color was 1995 Volvo that you owned in 2007? And I was like,
Wow.
So I think the other question I would have is, once, in that situation, let's say there's not a rich history for an elderly person, but somehow their great nephew gets online and can answer all those questions. They then also have to upload their credential and go through credential analysis, and then they're on camera with the notary. So I would, presumably the notary would cancel the transaction, as well as once that person realizes that they're on audio video recording, which is typically kept, depending on the state, 5 to 10 years. We see that as a huge deterrent on our side, because I do understand your concern, and I'll still check into what a sample set of questions might look like, but that's kind of where the audio video recording becomes a huge piece, as well as the ability for the notary to cancel the transaction at any time if they feel uncomfortable or feel like there's anything happening on the other side of the camera that may not be on the up and up.
These are similar questions that you get if you're applying for a new credit card at the same bank. So they are out there. I haven't heard a lot of issues with the naughty nephews. I know that it definitely is a thing.
Yeah, and that's frankly what one of our organized opposition to this bill may be judges highly opposed to elder abuse. And so
Okay.
we should be sensitive if we're going to say, look, Judge Triumvirate, what we've taken. And those questions that I saw aren't going to fly. I think it's a perfect thing for notarizing real estate transactions, but if you assume you have a very competent, very capable 75-year-old, they're not going to be able to actually manage to do all the tasks, or most, I shouldn't say all, many responsible, capable 75-year-olds aren't going to be able to know how to upload, aren't going to be able to know how to scan. I mean, that's going to be a complex situation for them. So you're not recording when all of that occurs. All you're recording is when the notary comes on the screen. So you won't have seen all of that potential confusion, which may be a good thing, because if the person's competent, you don't want them to not be able to access it. But if the person's not competent, all of that is hidden.
The only other
Correct.
item is
So
also,
are you thinking even in the context of wills, since that's excluded from UEDA in your state, or, and typically we see states leave wills alone, or just
So,
anything?
Renee, hold on one second. There was, I want to make sure you're able to, no problem. Renee, can you repeat?
So I just want to make sure I'm addressing, or at least have the full context of the concern, so I can make sure when I'm also going back that we're thinking through everything. I guess, are you just more concerned about the power of attorney type of document, or I believe you guys should probably deeply consider excluding wills from the legislation?
Now we can notarize the equivalent of living wills in Oregon. We used to not be able to do that, but as of January 1st, we do. I'm not as concerned. Usually there's not a big fight over who's going to make healthcare decisions, although that does happen. The irreversible things that we can't help people with is after the money's gone, the people who take the money are generally judgment-proof.
Okay.
And so I'm just thinking about, what kind of protections are there, not only to allow people who are older to use the system, but to protect them from abuse in the system. And we have already had the conversation that, yes, you can show up at the bank with your naughty nephew and just present an ID. But I'm not saying that's the perfect solution either, but I think there's a lot of room for abuse with this. If you can go to grandma's house with your iPad and put her on the screen, I don't know, it just seems more ripe for maybe some built-in protections. I don't know what those are yet. I'm just challenged by it.
Okay.
Other questions?
Any questions for anyone else on the phone for Renee?
Hearing none. Thanks very much, Renee. That was very helpful. Gives us context for what we're talking about.
You're welcome. And if you guys do need me at all to go over it again, if I'm invited, I plan on being at the next meeting, and I can always do an in-person demo as we're going through things. I've found with every work group, it seems real easy up front until we start digging into the weeds. So I'm glad to always just show whatever piece at the time, if necessary, as we're discussing things.
And Renee, you're certainly welcome to continue to join us. So however that, I know you're in Michigan, so however that's convenient to you.
All right.
You're on our list, and you'll receive all my emails.
Okay. Hopefully it's on the good list. No.
Thank you. Well, just kind of following up on a couple of Heather's questions. And we've got Pat and Cleve here from the title industry. A transfer on death deed, that could be an irreversible kind of transfer that might happen with a elder kind of person. How would that be treated if there's any like that in a closing?
They don't guarantee.
Well, I mean, a transfer in death is very much like a normal. So it goes through the same signing process. So I don't know where the organization component gets stored. Maybe doing it with the lawyer. The lawyer can sure by form of transfer. So hard to know how get it back there.
So, but
Then there is a statutory provision with the 18 months from the date of death. We're involved before the 18 months is expired. We all have our own underwriting and vetting processes for that period of time. Because during that 18-month period, the law presumes that if some other relative challenge the fact that nephew talked grandma into signing a deed, she didn't know what she was signing, that it would happen within that 18-month period. But we don't create transfer on death, presented for that. After the person is deceased.
But a deed signed by an agent under a power of attorney.
Kind of check. So that it is usually can be they know they're going to be out of town and they want somebody to but it's also going to be estate planning. And those are the examples where attorneys used 5, 10, 15 years ago. Title or something like that.
Well, and if we have a current transaction where the attorney in fact is seeking to sell the principal property, we also again have our own internal vetting and underwriting processes because that situation always has risk regardless of POA at the time.
Do you think you would see that as, so sometimes the title company asks me to sign a letter that I was the attorney who drafted the power of attorney. At the time the power of attorney was signed, the principal had capacity. Until we meet our underwriting requirement for title insurance quickly, but would it be appropriate to guess that if you see an electronically notarized document, you might have a greater level of review or stricter underwriting, I guess?
Well, I think that's certainly possible. Might be, want to look at the notarization. So it may be.
And see the video.
Right.
Really quick, for those speaking on that side of the room, I just got a note from someone. The microphone's right there. Could you just move it over, just to make sure that everyone on the phone can hear you? Thank you.
Well, I mean, remote notarizations that fix everything, which is obviously still going to be the rare code and everything like that. But the one thing it does give is that we don't have a state as well as the ability to ask for that copy instead of asking, did you sign this and were they okay? And then your opinion will also cover myself. So yeah, they were good, they knew what they were doing. You don't see what happens before, but at least in a mortgage transaction, my company workly does the mortgage transaction side. There's a lot of steps and interactions up until that point to tell us whether or not they really could do it. So a lot of our interaction is online still, so they would be able to do that, or over the phone, you can tell who am I speaking to, or with the banker, those recorded calls, like, was the first initial contact by naughty nephew, were they telling us that we had to convince them to put the real mother on the floor for him, you know, so you have all of those items you can pull from in the case where it's just like,
Okay, just want to let you know that we've got a big article. It looks like it just.
you don't always care.
Yeah.
Not to say that.
I just opened it, talking about losses.
And just out of, I guess, ignorance, how does one acquire the audio-visual record?
For us, you can download the video yourself. The title company will know which provider was there for it, and then they should have, a lot of the title companies are requesting a copy at the closing, so they have it as well. And if it's not, then they'll at least know which provider provided it, where it's stored. The SOS office can get involved if it does become an issue, but everything will be on record there for the notary's journal requirements, or whatever the state decides to do with which provider they used and when it was.
Okay, so that's assuming that the notary is still offering notarial services.
Right.
Okay, so we're looking for a record that's 2 years old. Notary has decided to go to American Samoa or wherever they want to go. And then we're looking for a record.
Right.
Is that housed at the Secretary of State's office or how?
I can't remember. Oregon has this journal
So-
requirement currently. Right.
Yes.
Oregon does have a journal requirement,
So that would be with the
so
other.
it's 10 years from the date of the last notarization. One thing that my thought would be with this, that I think it should definitely be something that the notary is responsible for, because that's part of their responsibility to have that information, but also, I think upon request, the Secretary of State should be able to go back to whoever the provider is and be able to request that information directly from them.
Correct. Yeah, so this
They stop.
is Renee.
Don't they usually?
So, to Liz's point, typically how states have written the law, as well as how, MBA also suggests, is that it's on the notary to store their journal as well as a copy of the AV recording. However, it is also, the notary's option, as well as in some states, the requirement that the provider also hold on to a copy of that document, or at least be able to validate that that document, was executed on their solution through audit logs, as well as have a copy of that audio-video recording. And on top of that, if it's in the real estate realm, you have underwriters who require that the title agents themselves either store a copy of the audio-video recording, or the underwriter themselves wants the copy. So I hope that helps as well.
The notary runs away and doesn't tell anybody that they're leaving. They
Yep.
take all their stuff, or let's say they set their house. And then someone needs to recall that recording. They can see it was a Quicken Loans loan, okay, and then Quicken Loans could pull the information. Who did they close with? What title company? What provider did we work with to give them the documents? And then you can retrieve it that way. But there is some safety fallback you just have to go through. And the one thing is always.
And then on our platform, you could always come directly to us. And if you're with a valid request, a Secretary of State request or regulator request, or even a subpoena, we could provide copies of those records, including that audio video recording.
So I'm the attorney, I see a power of attorney that's questionable, and I want to check the notarization. How do I know which company provided the notarization? Is it on the notarial certificate? Bob working for Smith Notaries, Inc., or, I mean, how do I know that?
So ours does, the seal, will tell you that it has been notarized on our solution. Additionally, I can't speak for, sorry.
The seal that they use?
The
should
seal.
say-
Yeah.
Okay, and ours is the whole mortgage thing, but if you're doing it outside of that, the seal should tell you who it was. They should have some kind of mark on there to claim it as their material.
Okay.
But I think, one point this year, right now, the notary journal is kept by the notary, and then the notary is responsible for either keeping it for the time period, or can enter an agreement with her employer. The journals will be turned over to the employer. So many title companies use that approach. But if you can't, I'm not sure you can tell that from looking at it.
You know what you do?
can, but just give you the number, this will help you identify the number, so you can contact the Secretary of State's office.
And when you contact the Secretary of State's office, they give you their last contact address for the notary. You probably know that. And then you can I've contacted notaries, and what you get is a copy of their journal page for the act of notarization, which isn't nearly as valuable as that audio-video recording. True, but also some of the human protections from human interaction are.
But I think the fair question to ask, where do you go if you're looking for a remote notarization? And how does the notary make sure that she or he is keeping records themselves? Normally, the notary is going to I don't know where what's the station, I think. If you use the service that then you probably you go to the Secretary of State's office and say, yes, I'm going to do, or may do remote notarization. I don't know what, depending on which law.
I can kind of answer that one. So the SOS office can establish standards for what your journal keeping requirements are for your at-home network, or however you want to keep it at home if you are going to be responsible for it. They can set, it has to be tamper evident, it has to do all these things, and you can, a lot of times we'll update technology as time progresses. And a lot of the states are opting for allowing a repository to hold for the notary as well, and that way you can make sure that whoever needs a copy of it can hold the copy, and then you have more than just the notary at home. It depends on the provider, what they prefer. Renee, do you want to tell us what Notarize does? Do you guys actually employ the notaries? Or how you keep records, or what you do?
So how we keep records of the notarial transaction, or?
Yeah, so is it the notary themselves at home on their computer, or how do you guys track this? Do you guys actually employ them?
Oh, we actually track it for them in an audit log. So in the event they were to leave our employment, we could then download a copy of their full audit log and give it to them. But we'll also still keep a copy of that in our possession, since we feel it's our duty to ensure that we can help in the instance the notary is no one can locate that notary. So we do keep it for the notary right now. However, I guess nothing is really stopping them from keeping their own side journal as well. So I think the one thing to keep in mind is that notaries should be allowed to keep at least multiple electronic journals, because they could be using multiple solutions. I know that's the case in the in-person electronic world, and I do believe that is going to be the case in the remote online notarization world. So it is important they should be allowed to keep multiple, as long as they are, as long as they chronicle everything as the notarizations happen.
So what they want to do, Ron, they have to go to the SOS office and say, these are the providers that I want to use, depending on how the state writes the rules. But typically what we've seen is these are the notary providers that I want to use for remote online notarization. And then the SOS office is okay with them or they're not, depending on how they do their standards for it. And then they can say, these are the technology this is the technology I'm going to use to record my journal, and this is how I'm going to retain my audio-visual recordings. And they're either up to the standards of the SOS office or they're not. So at the time of renewing the commission or requesting the new commission to become a remote notarization, that's when the SOS office has control over whether or not it's up to standard. And it is up to notary then to stick to that, obviously.
Yeah, I think that would be a concern, you know, kind of a tangential issue is something like Notarize, yes, they keep the record and it's probably secure, but if they're letting the individual notaries have multiple electronic records, where's the oversight for privacy and security of those electronic records in the hands of the individual employee or notary?
Well,
You know, they leave their laptop sitting on the front seat and run in for coffee and the laptop disappears. That's the problem.
Right.
Yeah.
So they would only have multiple if they're using different platforms. So if someone who's using Notarize would not use their Notarize platform for the next technology. That's the only reason it's.
But if the notary also maintains the notary's own journal, electronic journal, who has oversight over how the notary is keeping his or her own?
That leads into my next question, because, you know, I'm just assuming that, you know, the least common denominator out there, my plan on keeping my record of electronic notarizations is buying a bunch of flash drives out of Office Depot and, you know, let them rattle around in my drawer. And I mean, that comes, I guess, to the Secretary of State saying, is that compliant with the standard that, you know, we're going to require out there? I guess I'm asking, is there at least some standard for, shall we say, the least common denominator out there in the big wide world for remote notarization?
And if there is, how does it get imposed and then policed?
Well, we have an agency, and so.
Well, yeah, and I think that there would have to be something in place. It's just a matter of, like, any type of enforcement type of, you know, you can only do so much, and so I'm not sure how that fit into everything.
So I think the thing to keep in mind is that the journal itself won't contain or shouldn't contain or be required to contain any more information than is currently required in the paper world. Meaning if a notary loses or keeps 5 journals, whether they're supposed to or not in the paper world, it should be that same information that was required in the paper world. The audio-video recording should be a notarial record, but it shouldn't be required to be kept as part of the journal itself, which takes away from some of that personally identifiable information, meaning me as a person, I'm on screen, my biometric information, but otherwise there's a reason why we keep KBAs and the actual images of the documents themselves off screen. It is only those talking heads, so it's just me and the notary talking, and then the audit log that flows with the document should match up as we're talking through things. So then I don't have my social security number. I shouldn't be saying it out loud on a camera. I guess there's nothing to really stop people, but at least it's not all of the documents being recorded.
So this would be the same, like if the notary keeps their journal in their car and someone steals their car, they have the same information they could if they stole their laptop. The only thing they may be missing is the talking heads, and they wouldn't have any documents in the recording. It's just what were we doing at the time in the video and what were we talking about. But a lot of times you're not going to say, like she said, your social security number in the video, but then you audit log to link it up with the documents that we have signed to match. So that way you can say, you know, 1301 in the video, you signed this. What was talked about 10 seconds before that?
So maybe I misunderstood. When the signer shows his or her driver's license and then flips it over on the camera and shows the flip side, is that not part of this video record?
It depends on the state law, but for what we've seen in our state for Nexus Technologies, we only show the front, we don't flip it for the back. The credential analysis where you do the pictures, the front and back, that's not in the recording. you only start recording when both of you signed in, and it's only to say, like, let's see the picture on the ID, and she'll be physically in your hand, and then I can feel like, okay, that does look like you, as another form of making sure that they have what they need to do the notarization.
So, and I'll be honest, it's the one thing that on the notarized side, we discourage requiring the holding up of the front and back of the driver's license again on camera, because you already have the images of the driver's license that are uploaded for the notary. We have those captured in our system, but again, it depends on how you write the law and how the regulations are written. If you really want to require someone to again hold up that driver's license, I think the key being you can't exit the workflow, meaning you start credential analysis, you have to go all the way through to the closing without canceling the transaction, so that way we know, or the belief should be, it should be in your possession at the time. So it's just a little bit of difference there.
Okay. Any other questions or thoughts about this area?
This is an odd question, but as a practical matter, we've talked about maybe a notary leaving Notarize or one of these other services. What happens if Notarize or one of these services goes out of business and you have this group of videos and documentations? Is that something that would go to the Secretary of State's office? Do other states contemplate that kind of issue where the entity itself goes away as opposed to just individual notaries?
It's a lot of times in the state, how the law is written on what the fall throughs of that, when it becomes an acquisition or when it becomes, someone closing the door, and how to handle it. Similar to like a lender, we have our process that we have to follow, our documents we have to keep for a certain amount of time, and where it goes, and the SOS office would be involved in drafting those rules and stuff.
Okay.
I have a technology-related question.
How about it?
For Renee and anyone else who has familiar with the software. Is it possible to actually conference in a third party? I'm thinking about a scenario where I want to use a remote notary for a client who lives in, Eastern Oregon, but I want to be on the call also and watch it go down. We add in a third person?
Yeah, like that. Some platforms, not a lot of, but a lot of them are. So you can have the closing agent on there if you want, and the notary, and the real estate agent doesn't feel like they need to be there, and the client. Or you can do two clients in two different states, signing, and both of them have their own login, so they can't sign for each other, they can only sign for themselves.
So are there essentially two records, journal stuff?
It's one documented video. So it's just talking heads, so it could just be the two heads next to each other throughout the whole video. So you can watch it all at once instead of watching this one and then this one later. So it combines it all into one. Oh, sorry.
So the question was, there are also the journal stuff, which is kept separate from the stuff.
Yes.
So if you wanted to look at the talking head stuff, accessible by the notary or by the officer.
Yes, they should be easily accessible as a journalist, but we prefer they're kept separate because they might have many other documented, so the size of the file of the journal might be easier.
So, let's say we're now 3 years past the actual signing of whatever this was by a remote notary, and it's now the will fight that is transpiring in some court. How does either of the parties or either of the contesting people get hold of whatever record there is? I mean, am I subpoenaing,
It would have to be an official request, so from the SOS office or a subpoena from the court to review the.
In other states, they also, we would allow if there was a subpoena. So yes, you would just subpoena either the notary or the provider, or if for some reason the Secretary of State's holding on to the information, the Secretary of State.
Okay. So am I correct then that all of the remote notarization platforms, whenever there is a law that is adopted in a particular jurisdiction, they are then registering in that jurisdiction, so they're subject to subpoena? Okay.
So you guys will be subject to the subpoena of the court. What if I have a notary in Pennsylvania that notarized the document? Do I have jurisdiction to subpoena her?
That might be a court question, but.
I know,
And
well,
it's also similar to, because it would
So,
make the process.
I guess, would you have the jurisdiction today to subpoena her? Because
nope, but she wouldn't have the ability to notarize here either.
I know Iowa added in the language.
But if someone took a document from Oregon and they were vacationing in Pennsylvania and a Pennsylvania notary notarized it, you guys wouldn't accept it in Oregon?
Well,
I think we would.
if the person is physically
Yeah.
in the state where the notary is authorized, then it would be accepted. So the question on remote notarization is the person who's notarizing the act always authorized to be a notary where the person signing the document is?
No, so the one thing you'll find common in all of the states that have enacted legislation as well as the model laws is that the notarization occurs where the notary is located in the state where they're commissioned. So the Notarial Act in this instance would have occurred in Pennsylvania, just as if the person had physically been before that notary in Pennsylvania. And that is a key component of clarification in every law. Which is, it's as if instead of saying you have to be physically present, you join them in the presence over audio-video communication technology, and the notary was located in Pennsylvania, commissioned in Pennsylvania, therefore the act occurred in Pennsylvania. I hope that makes sense.
Even though the person is sitting in Oregon?
Correct.
So unless we have some kind of, I didn't look at the statute specifically for that, but unless we have some kind of statute, I don't think you have jurisdiction to subpoena that notary's records because are the contacts sufficient? Yeah, I don't know.
I just asked the question. I don't-
Yeah, that's a good question.
Don't have an
No,
answer.
it's a good question.
It's one of the questions that
I would assume, and I totally could be wrong, because I have not looked into this, but we could definitely do that, is,
Yeah.
like, if I'm a mortgage banker based in Arizona, and I'd like to bank in Oregon, but I'm still liable to be subpoenaed by the court to provide documents or even my own testimony.
and that goes to licensing rather than state. That's
So
where the tie is.
It may be within the commissioning of notary that's ruling right, I'm not sure, but I think that's a look into it.
That was something that we definitely need to do with our statute right now, will need to be changed just for the notary requirements, when they apply. And we do want them to be, in Oregon, if they're going to be a notary in Oregon, whether it be remote notarization or whatever. I just need to make that adjustment so that they do have to actually be in Oregon, or maybe even Oregon and one of the neighboring states, but,
Or simply consent to jurisdiction of Oregon courts.
The mere act of-
Also, one of the things, and I don't know if this helps you guys, I'm sorry, I'm not as familiar with all of Oregon's laws, but I would say one of the things that you didn't hear in the script, which is you consent to the jurisdiction of whatever state that notary is located in. So it's also declared on the video. I'm not sure if that'll help you out, but that is part of the script that we would use. And
Did anyone hear that? I want to make sure. Okay.
Which would give Pennsylvania jurisdiction over our probably diseased clients.
Because you can close a loan in Hawaii in California,
Right.
but it's Hawaii land and recorded documents.
Right.
But the notary was still living in California. So in a way, remote notarization, I mean, but it does still continue on with the reciprocity in that way where the Pennsylvania, Oregon can sign documents for an Oregon property. But everybody was they were located in Pennsylvania and commissioned by Pennsylvania with the way that the reciprocity works between states.
Yeah, so, but our question is, if you're in Oregon and you've got that Pennsylvania person as your notary, then you're subject to the jurisdiction of the Pennsylvania court, not the Oregon court.
Well, wouldn't that be the way it is today? That's why I'm.
No, because the person is physically present.
In Pennsylvania.
So
Yeah.
if the person is physically present in Pennsylvania when they notarize,
Right.
yeah, but if the person is physically present in Oregon when the Pennsylvania notary notarizes it,
Right.
then no.
But if you're buying out of state, that's where I think you see a lot of it. And like from my experience, because my parents did move to Hawaii and they closed everything at home in California. So that wouldn't apply to them. So that with the same, I'm just asking the question too, is would Hawaii deal with the California notary in the real physical appearance way?
Or get to their journal.
Right.
That's the thing I'm concerned about, is getting to the journal.
Question for you.
Sure.
Research the jurisdiction issue.
I have a note right here on reciprocity with jurisdiction. And then is that something you're going to check in with your company as well? Okay. I'm going to look at it as a broad scheme, but also since we have a representative from one of the mortgage makers. Thank you.
And I can look at how the other things are done too. Not everybody, a lot of them are using it as a model, but it is something that we are concerned about.
Yeah. We
To not interrupt current processes.
Okay.
like to solve the problems.
So I'll bring back a very short report about this next meeting.
Yeah, sounds like it could be dealt with. Sign off on.
I'm curious, anyone on the phone, because we do have some of the national folks, is anyone on the phone aware of how this issue has been tackled by other states who have passed these laws? Tim, maybe?
No.
I know Iowa has something, I'm gonna look into it.
Okay.
They wanted to make sure the venue of any issue was going to be resolved.
Okay.
So I think that's.
I'll take a look at their statute.
Yeah. Okay, good. All right, any other questions before we move on to shall we say, the competing model acts? Okay, hearing none. Has anybody taken a good hard look about what, whether the Rulona is the preferred route or whether the MBA is the preferred route? And since we have title people here, I'd certainly like to hear.
Well, I exchanged emails with Michael O'Neill.
Mm-hmm.
We hope to participate in this meeting, but we have another
Can you use your microphone?
We've moved it closer.
Put it in his mouth.
Can't do that to Cleve, come on.
You hear me okay again?
Just barely. I'm straining.
Right, well, Mike, right close to me, but
Thank you.
Michael O'Neill responded in an email to me that ALTA is fine with both approaches, the Vermont approach and the LTA model. It said that the Ramona one was put together as a plug-in, but a draft of the existing law. And since we have that in Oregon, then using the plug-in aspect of it makes it a better fit for us. If we were starting from scratch, we might think that an LTA model has some advantages, but that it's kind of just the reverse because we already has Ramona already adopted.
Right.
So from our standpoint, we go with the 2018 version.
Okay. Liz, what does industry say about?
They are equal in our eyes.
Okay.
MBA also was designed to try and fit in where Rulona was missing. So a lot of states are turning to even Rulona after establishing MBA also to redo all of their laws and make it more uniform across the nation. So I do think Rulona is the ideal ideal way for you guys to go. It has the same language written that you don't have to redefine everything. But they're right, you can take stuff out of the Alta model that may be missing from Valona if you want to add those in.
Okay.
Do you know what's missing?
It depends if you guys have the paper route issue some states have. Like, do you guys all have e-recording in all of your counties?
No, I don't think that's true. We don't have,
The NBA also has language you can basically copy paste in there to handle those situations. Some, when I was speaking to Nebraska, originally they were gonna go for just make everybody start e-recording and just kind of like to push in that direction. And then I think the reporters were like, we don't have money for that, so they put in the NBA alpha language in there, so.
from,
I didn't have a chance to really discuss with Peter about this part of it before, he was out of town, and me as well, out of town, but, I would assume that we would want to try to stay close to how we are now, not maybe probably with the goal now. But I just have to also check in with him too.
sure. Understood.
I do have a note from, I'm sorry, Mark.
Go ahead.
I have a note from Lynn Shetterly, who's the current chair of the Oregon Law Commission. He did want me to express to the group that if we were to choose a route other than Rulona, he does feel that the commission would actually have to meet again to reauthorize this group, because it is very specific that we be operating with Rulona for the proposal if they approve. That wouldn't necessarily be an issue, but he did want to make sure that the group understood that.
Yeah.
But if we choose to go through with Rulona as a base, we can continue to move forward as we've been doing.
Kevin or Ken, do the bankers have an opinion of which of the acts?
Well, this is Ken Sherman. I'm pleased to hear Cleve say that the title companies think that in our case, the Rulona is probably a better choice because we have the existing legislation around it. I would be interested in knowing more about, and I can do more review on my own, but in terms of any patches that we might need from the ALTA Act to improve the coverage under the Rulona. But I'd be inclined at this point. I've read Rulona pretty carefully, and I think I understand it, and I think we should be comfortable with it. So I'm inclined to say go with the Uniform Act. I do have a couple of comments, pretty modest, but I don't know whether this is the time to start talking about the actual provisions of the Act.
It is now.
Oh, okay. Well, I really just had a couple of things. The first is kind of in the form of a question. I'm looking at page 10 of the Revised Uniform Law and Notarial Acts 2018. This is the short document that just deals with the original and now the amended form of Section 14A. So on page 10 in paragraph F, it says at the end of that paragraph, the recording must be retained for at least 10 years after the recording is made or as otherwise required by rule under subsection H4. And then if you go down to H4, it says that the rules, among the rules that the Secretary of State can establish are rules that establish standards and a period for retention of the audio-visual recording. Reading those together, I don't think it's really clear that the minimum period of retention will be 10 years. And it seems to me that it should be a fairly long period, like 10 years. But I think if you read that first language, it can be read to say, well, it's going to be 10 years or whatever comes up under H4, which could be a shorter period. So I think it might be appropriate to clarify that if everyone agrees that we ought to have a 10-year retention period, to clarify that the rules may, I suppose, adopt a longer period or other standards for the retention, but that the retention period should not be shorter than 10 years. That's my first comment.
Okay, great.
And the other one is kind of related to it. There's in H, there's a series of things that the the agency can adopt rules on. And I would just ask that if we're going to go in that direction, which I think is fine, that we, in drafting this bill, provide for an operative date as well as an effective date. The effective date would be the date that the law becomes officially effective in the state, but it doesn't become operable until a later operative date, which gives the agency a period of time to come up with these rules, and more importantly, gives notaries and their organizations time to assimilate those rules and train for those rules and so forth. So I would think that we'd want to have a period of at least 6 months between the effective date and the operative date.
Well, Ken, I think we're talking of, this would be potentially a 2020 bill.
I understand.
And then, assuming no emergency clause, that would be January 1 of 2021. So are you suggesting then a period of time, 6 months, a year, whatever it is, for Secretary of State to promulgate rules? Or
yeah, I think you make a good, what I'm trying to say is that there needs to be a decent period of time between the finalization of whatever rules are adopted and the date that the new rule becomes, the new law and rules become effective. We've seen too many situations where we get administrative rules on the 11th hour just before a new piece of legislation becomes effective. It creates chaos. And so I'm just saying, I'm not trying in any way to delay the effectiveness. If the Secretary of State's office doesn't feel that they need to adopt rules, and I don't think it's mandatory under this, I think it's permissive, but if they don't need them or they can do them quickly, then so be it. But I think we need a reasonable period of time. I would say 6 months, maybe we could go with 4 or something like that. But we've got a lot of notaries out scattered across the country or across the state who are going to have to be trained to understand how this works, and a lot of technology to put in place.
Good point. From the Secretary of State standpoint, what kind of time period is preferable or doable?
I think knowing when it's going to be signed and how much time we have between the time that the bill is actually signed to when it goes into effect, that gives us a lot of time, a good amount of time to get things going. I know that we will have to, rules are definitely going to be something in play. We're definitely going to have to make some adjustments there. So we definitely need time to do that. As far as the amount of time, I would probably have to ask our director to make sure.
Okay. Well, legislative session ends June-ish, and effective date without an emergency clause is the January 1, so that's a 6 month. Okay.
And the short session is even shorter. Yeah.
Even more, yeah.
It'll be more time, yeah.
Would this contemplate hiring, and just think that you're hiring a vendor, the state would hire and retain, so there'd be an RFP, there's a rulemaking process? That would be one question.
I'm not.
Well,
What was that last question? I might be able to help.
Kevin?
Yeah, it was more a question of Secretary of State in terms of whether or not there would be, beyond just rulemaking, the need to hire a vendor of some sort, whether it was someone who actually performed the contract with, does the notarization, or something else. And
Okay. All right, sorry.
Requirements that we would want to have in place for whoever the vendor would be. I'm not sure that we would be the ones to actually hire the vendor. I think that would be up to the notary to decide.
Correct.
Right.
So how it works in most states is the Secretary of State, maybe there's a registration process, so you're aware of who the vendors are out in the realm, and there's specific pieces of information. I won't go into too much detail now, but glad to provide what that generally looks like, so that you know who the vendors are, and there's a list of vendors that notaries can pick from. but it's on that notary to choose which vendor they're going to hire or use or work with.
And each vendor will train them to their platform and how it works. The Secretary of State is not responsible for that.
Right, okay, good. All right, well, I'm just asking, do we have a consensus that we're talking about the Relona platform for this act, subject to some desired add-ins or clarifications? Is that what the consensus of the group is? And if you disagree, feel free. I mean, okay, not hearing any strident opposition there. So let's. I guess the next steps for this group is to essentially decide what the desired add-ins might be, and whether it's the authorization for e-recording everywhere, or clarification on jurisdiction and subject to service process, that type of thing. Is there anything else that we can kind of put on our wish list?
Just what I talked about the last meeting, which is currently in Oregon, the notary has discretion whether or not to notarize a document where a person may be impaired. And I had suggested that we modify that statute to prohibit the notary from notarizing a document where the declarant is impaired. And that was the difference. In real world, is that going to make a difference? Well, if I can sit in Pennsylvania and I'm only subject to the jurisdiction of the Pennsylvania court, and I can notarize a document of a little old lady in Oregon, I'm not too worried about it. But I can do that today.
Yeah.
I think we should still have something in place though. And I think it's almost as easy as a word change. Instead of saying that they may, refuse, I think they shall.
So essentially, prohibiting a notary or requiring the bailout of the transaction if they have a question or questions about it. Okay.
And then the kicker question in Oregon is because we have innocent bystander liability for elder financial abuse. What does that do? That's part of the jurisdiction question. And is the innocent bystander liability just the notary? Is it the notary and the software company? I mean, those are questions that are good questions, and today we don't have those protections. I can sue the notary in Pennsylvania because I think there's sufficient contact, but that's a good question.
Sounds like we have tasks for next time.
So anyone, and this is for folks on the call too, who, as you read further, comes up with other questions that we want the group to discuss, if you just want to send to me prior to the next meeting, I can create documents, I can highlight certain parts within the act that we need to discuss, and as we're creating the agenda, we can focus on that. So just send those things directly to me, and I'll get those distributed as they come up.
And Ken, Sandy has taken notes of your suggestions here, so you can get those put together, and anybody else that wants to have a suggestion or raise a question that we haven't already raised, that should be for next time.
And we'll try to work through solutions.
Okay.
And then, oh, I'm sorry.
Go ahead.
Someone on the phone?
I said okay.
Okay, thanks, Ken. And really quick, Liz, you said you would like to have the opportunity potentially to present a different platform just so people can show the differences?
If you guys were interested, I mean, they're relatively the same, but if you guys did want to see a different platform, we could definitely do a demo on ours, or
we'd be happy to look at it, like to see, how it works on various platforms.
So I think that's a yes.
Okay. So, Sandy, you'll send out a calendar?
Yeah, are we thinking 2 or 3 weeks again, kind of like last time, before the end of?
Last week of June.
You're looking towards the last week of June? That would work for me theoretically.
I don't,
Council involved.
Yeah.
Could be problematic as a session.
I don't know if we need them quite yet, though. I guess she wasn't able to show up today, I think for that reason. So, but if I send out a calendar request based off that last week in June and a few dates that are possible, does that sound okay to everyone?
I know,
I'm going to be out of the office from June 20th through the 26th, or whatever that's worth.
Or maybe the first week in July as well?
that's July 4th.
Yep.
That's true. Well, we'll
figure it out.
I'll send a group of dates out there and we can figure it out. But around that time frame makes sense to everyone?
Sure.
Okay. It would be somewhere between the last week of June into the first maybe couple weeks of July.
Okay, last week of June, I won't be able to do the demo, but my chief in Detroit might be able to do it for us, and I would have to do it on, log in through the phone.
Okay. However, I mean, we can work it out. I can, if we're using this room, I certainly have the technology available. So.
Okay.
All right.
Sure.
Yeah.
As I mentioned earlier, I think, within the Mona, the question of whether you want it set up so a notary can log in, like you need a special certificate or just remote authorization, or whether that just comes with culture. But there's a higher level of training.
Okay.
How out of doing that, and it's not overdue. And, another aspect, bill that relates to electronic recording. I think.
My understanding is it did pass both houses.
Okay. Hadn't. Might be something. The thing that is, the 2425 name, press make it clear that for electronic document, not going to be doing all electronic. So that.
Okay. Well, we'll check to make sure that it gets signed, and if it doesn't, well, we may have to add in, so.
So it was, I just checked, it was passed by the House. It was passed on the 16th by the Senate. It hasn't been signed yet, but it has been passed by both houses.
Okay.
One of the things, and this is probably getting out there a little ways, data security is a big thing for our banks.
Yep.
We're under extreme scrutiny as far as third-party vendor liability. In fact, it's not just scrutiny, it's a hot topic.
Okay.
And we've got certain things that we have to abide by. And what we've noticed in some other areas is that becomes a sticking point.
Okay.
Especially if there's interaction directly between the bank and that. And so probably getting a real clear understanding of some of those security standards that we can pass on to smart people in our banks who can say, yes, no, that's good, that's bad. It's something that's probably going to be important because we don't want to be in a situation where we're going to go on.
Yep.
So
Those contracts to address some of the concerns, like, I know for us, we have high standards for whichever third party we work with, whether it be California or whoever, and we make sure that they are up to our standards before we do business with them, which some of your interactions will be, so that makes completely help, but I look into that and see.
Would you, I don't know if you or anyone on the phone would have almost examples of contract language that has been used that has satisfied banks in other states, potentially?
And Kevin, if you and Ken would figure out if you've got, the banks have some standards that at least they're somewhat comfortable with at this point.
In better yet, what our regulators are coming.
Yeah, there you go. Whatever, you know, whoever you have to please. But let's see if we can get some language, if we need to add it in here, and if it's going to be in regulations, then pass it on to the Secretary of State's office to make sure that we cover it somehow. Okay? Anything else for the good of the order? You've got 20 minutes.
All right, thank you all.
Thanks again.
Thank you.
Thanks.